got, Justin said we had some, he's gonna look at it, I said, not this week, but that door, if you look at it, it's angled, the floor's angled. You have to trim the door, make it even.
I don't know, man. I think there's one person out there. Yeah. Um,
All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning. We're going to start today with the public reprimand of Judge Martha Adams. Good morning. Judge Adams, after investigation, the Judicial Qualifications Commission found that, quote, while presiding over criminal cases in Orange County, you exhibited biased, impatient, undignified, and discourteous behavior regarding the staff and management of the Ninth Circuit State Attorney's Office, close quote. You have not contested these findings, and you have acknowledged that your actions violated several canons of the Code of Judicial Conduct. To your credit, you have accepted responsibility, expressed deep regret, and apologized to the individuals most directly affected by your behavior. Moreover, you have no prior discipline in your nearly 2 decades of service as a judge and no prior complaints of this nature. All that said, you engaged in behavior that our judiciary cannot and will not tolerate. Behavior and expressions that show bias against any party are deeply damaging to the integrity of the courts and to public confidence in the fair and impartial administration of justice. And no judicial duty is more fundamental than our obligation to treat every litigant with civility and respect, even under challenging circumstances. Please ensure that this doesn't happen again. Your public reprimand is complete and you're free to leave. Thank you. Okay, our first case today is State of Florida versus Michael John Phillips, number 2023-0073. Go ahead.
Good morning, Your Honors, and may it please the Court. Robert Shank for the State of Florida. By voluntarily reopening the package of sanctions that the trial court imposed on him, Mr. Phillips defeated his own expectations of finality in that package. That undermines no promise under the Double Jeopardy Clause. That clause is neutral as to sentencing. It leaves to the legislature to determine when a defendant has an expectation of finality. And all of the federal courts agree. In a package jurisdiction, a defendant has no expectation.
Can we get past the, it seems to me like this package business is a little bit of a bumper sticker, because it is possible for example, sentences to be run concurrently or consecutively in a regime, a sentencing regime, and yet have it be different in some other way from the federal sentencing regime. And I think the parties, in this case the state as well as Mr. Phillips, have briefed this as if it's a binary choice. Either it's a package model or it's not. Where it seems to me the criminal punishment code reflects there are some respects in which the enterprise of sentencing is multi-count assessment. Obviously, it's baked into the score sheet that we look at a total offense level, but yet we have a separate sentence as to each count of conviction. There are both separate and package elements to it, and it doesn't seem to resolve the real question in this case, which is what is the defendant's legitimate, constitutionally protected degree of finality in a sentence that not only has he not appealed, but that the state has not appealed, and that is illegal or incorrect. And I wonder if instead of making this an argument about package, no package, you might address what constitutional interest a defendant has in a sentence that the state doesn't appeal, even though, in retrospect, is not the sentence that is demanded. It's not the LPS that is generated by operation of the score sheet. And yet the state is silent when it's entered. What constitutional interest of finality does the defendant have in a case like this?
So, in terms of constitutional interests, generally what we see are two constitutional interests at play when we talk about sentencing and one of the counts gets vacated and remanded. So I do think that the federal court's approach, well, first, the two interests I would say are the double jeopardy clause and the due process clause. Now,
and there's nothing textual in the double jeopardy clause that says that I have this this interest is protected. But of course, we are operating where so that our double jeopardy clause and the federal the U.S. Constitution's double jeopardy clause are textually identical, and both this court has acknowledged the sort of coextensive nature of the protection, and therefore we're sort of operating under U.S. Supreme Court law, which has identified three components of the double jeopardy protection. Okay.
Yes.
Would you concede that the text of the Constitution, frustratingly, doesn't answer the question here?
No, but certainly, I think after DeFrancesco, the Supreme Court has interpreted at least the sentencing portion of the double jeopardy clause. I mean, a lot of constitutional rights are somewhat opaque and have to be elaborated on by the courts through looking at the text, but also history and tradition. And in DeFrancesco, the Supreme Court said that it wasn't a bar to an increase on remand after it had been imposed.
But DeFrancesco just gets you to the idea that under a given sentencing regime, there would be nothing constitutionally that would prohibit the sentences on the unchallenged counts from changing. It seems like the way the federal courts look at this is that there's kind of a two-step process that they go through. The first is just kind of jurisdictional almost for the trial court. When the case comes back, like what are they, putting aside the Constitution, the due process clause, like what are they allowed to do? And then the question is, okay, assuming they have authority to look at the other non-challenged sentences, then did they do something that would then violate the double jeopardy clause? So in our situation, it seems like the threshold question seems like it would have to be, given that those other counts weren't challenged, or in this case, the one other count wasn't challenged, just as a matter of sort of almost like treat this not as a constitutional case really, but as a statutory case or an inherent judicial power case. Like what, should we be looking for something in the criminal punishment code that says judges on remand can relook at whatever? Do you agree that if the CPC said that, hey, defendants, prospectively, if you appeal any part of your sentence, just be prepared because when it comes back on remand, if you prevail, all bets are off. Like you agree that would make this an easy case, right?
Yes,
okay.
I do.
And so should we be looking for some kind of affirmative grant of authority to the trial courts to engage in this kind of relooking at the other stuff? Because if there's no authority for them to do it, at that stage, then the double jeopardy issue goes away. Do you agree with that?
So I do agree if there were an affirmative grant that would go away, but I don't think we need something that says explicitly, Florida adopts the packaging approach. I think that... Well,
it wouldn't say that.
Right.
I mean,
right.
It would say it would be some sort of an affirmative, because part of the problem here is that this whole reasonable expectation of finality is a function, one way to look at it is kind of in the abstract. If the sentences are kind of almost, as you guys say in your briefing, as a matter of common sense, even if they're not sort of interlocked in a way of a score sheet thing or anything like that. Like, obviously, you've got these 3 counts of conviction. The judge is trying to come up with something that's fair and that reflects the offense and the offender and yada, yada. Mm-hmm. So if you pull one thread out, you've got to redo the whole thing. That's kind of as a matter of common sense. Another way of looking at it would be that, based on the underlying statutory scheme. I just sort of know going into the game what the rules are. The problem with this is that we have no explicit textual indication of what the rules are. And if I'm talking about reasonable expectations of finality in terms of what a particular defendant in Florida is looking at, maybe as a matter of theory, there's no reasonable expectation, but it seems like we've got decades of just kind of practice in Florida that kind of tells these people, I can pick and choose what I'm going to challenge and it's not going to change. And so I feel like part of what our challenge is what baseline has, putting aside the constitutional question, what baseline has Florida law kind of established, and who can change the baseline? You know, one way to change the baseline would be for the legislature to just change the CPC and make it explicit. Another way would be for us to just say, hey, guess what? After however many decades, that reasonable expectation that you thought you had, it was never there because it's all interconnected and you should have known that all along as a matter of common sense, which sounds like that's kind of what you're asking us to do.
I don't think I'm asking the court to, engage in any judicial policy making about what is the wisest choice that Florida should adopt. But I want to back up a second and say I agree. This case is not particularly a constitutional case. It's a statutory case. The question here is whether Florida adopts the package model. And if it does, there's no double jeopardy interest. That's what the federal courts in DeFrancesco, I think, stand for.
They also, the federal courts, it seems like they look at the package. The package thing is sort of a court label, and sometimes in the cases it's like literally it'll be 2 counts of conviction where if you get sentenced for having a gun on one count, you can't do an enhancement for the other, but then the gun thing goes away and so all of a sudden it's legal to do the gun enhancement, and so they're intertwined in that way. But there's also kind of a prior, they look at the law and say, here's some grant of authority in 2250 whatever that says district courts can do yada, yada, yada. Like, is there anything in Florida that's comparable that kind of says when a sentencing court gets a case back on remand, they can look at the whole thing?
Well, as I understand it, I don't think federal law is particularly explicit as well.
3553A is pretty explicit, it sets out what a district court is supposed to do at sentencing, and it is a statutory grant in the way that Chief Justice Muniz just articulated. I think your best answer to his question has to be someplace in 775, right? The rules of construction that sort of talk about what a court is supposed to do. But federal statute does govern sentencing.
It does govern sentencing, but of course I don't think, at least not to my mind, they have an explicit grant about the extent of authority on remand. I may be wrong about that, but
it's not about remand in the federal. There is no limitation on what a district court judge can consider at sentencing, and there's an affirmative grant of statutory authority to the district court at sentencing to do a holistic analysis. And that's why the analogy is a little shot, because there is a whole statutory structure that governs federal sentencing that is absent at the state level, I think.
Well, I agree that there is a statutory enumeration, 3553A, about what factors a district court is supposed to consider in federal court. I think that Florida law also embodies somewhat similar principles. In my mind, what 3553A does is it embodies a very common sense understanding of how judges naturally sentence, and I don't see anything in the CPC that prevents the judge from considering virtually everything and exercising the discretion that the CPC gives him. So I want to point to 3 textual indications that we think indicate that that's so, that a judge is looking at an intertwined series of offenses in a multi-count case. I mean, we talked about the concurrent consecutive distinction. I think it is important because a judge can only exercise that choice by thinking about the total sentence the defendant is going to serve at the end of the day. I also think the most key part about the CPC is the LPS is a lowest permissible sentence. That calculation is intertwined. The judge calculates that by looking at all of the accounts of conviction, all of the harms from all of the counts of conviction, as well as the offender's prior history and several characteristics about the defendant, like his legal status. And then they take that intertwined score and it applies to every single count. And if that count, or if that intertwined score exceeds the statutory maximum, that intertwined count governs over the statutory maximum. That is
on a count-by-count basis, as we said in Gabriel.
Yes, that is true. That is true.
It seems like that's all fine, though, when you're talking about the initial sentencing. But really, the question, though, is once, both in terms of what the judge has to decide and then how the judge might exercise the discretion. But really, the question here is once you've undone part of it on appeal and you come back, what can the judge do? And that's, sort of the logic at the front step. Mm-hmm. The reasonable expectation of finality question just doesn't really go to the logic of the first step. It goes to the structure. I mean, why, so do you, if you accept the premise that this has been for better or worse, and I agree that if we could go back to step one, I'm not sure if what we're doing makes sense. But if this is just the way we do it in Florida and it's been going on for a long time, and I'm not sure that how persuasive the change to the CPC argument really is. Some of this feels to me like if this is going to change, why can't the legislature just change it? Why should we kind of reinvent the wheel decades into the game?
Sure. So I want to address all parts of your question. So obviously the legislature could do so, but the question here is whether the legislature has already done so. And I take your question in large part to be drawing on this court's opinion in Fazemeyer from 1984, where the court rejected the package model as it existed, as the sentencing statutes existed in 1981. Although the case was 1984, it was applying the 1981 sentencing regime in Florida. So I don't think that case binds you for two reasons. So first, Fazemeyer was before the sentencing revolution in Florida with statutory law. So in Fazemeyer, the way that sentencing worked is the judge would, have a bunch of counts before him, and the sentences on all of them were totally separate. They would give it an offense classification, and they would go into 775, and it would say, well, if it's a level A felony or a class 1 felony, you get 5 to 25, or 5 to 10, or I believe it was just a maximum. And so all the sentences stood really separately. And in light of that, I think Fazemeyer looked at the ban on general sentences and said that that type of ban indicated that Florida had rejected the package model, that sentences weren't intertwined. Now, we don't think that the ban on general sentences was ever that probative about the package model, right? There's a lot of reasons why a legislature may reject general sentences, yet still have the package model. If a legislature creates rules about individual sentences, it needs some way to police them. And also, the ban on general sentences is a good deliberative tool. What it forces judges to do is think about each piece in the puzzle in addition to the holistic analysis about how he's going to sentence them at the end of the day. So in light of that, then, and only after Fazemeyer, admittedly in 1983, there were some sentencing guidelines, but it wasn't applying that. And we had several iterations of new statutory systems that were reticulated and completely upended the way that sentencing was done in Florida. And so I want to point you to a case from the 11th Circuit that I think is particularly instructive. It's United States v. Fowler. And in Fowler, what the 11th Circuit was looking at was a packaging model case that it had decided before the guidelines were put into effect. And what the court said there was that prior opinion didn't bind it. Not that it was distinguishing it or overturning it. The panel couldn't overturn its prior panel precedent. It said that it couldn't bind it. It did not and could not bind it because the guidelines.
Can you address the premise, though? So it seems like we've had discussion about what are we looking towards to determine from a constitutional perspective whether this sort of action is prohibited. And so you've been presented with looking at the CPC and seeing if there's an affirmative grant of authority. I think the alternative, and it might be splicing words, but I think it's somewhat significant, is looking at the CPC and seeing whether this sort of action on resentencing is prohibited by the CPC, and then the I guess third alternative is looking at considering case law, considering practice, and considering the statutory text, whether there's just a kind of a culture in Florida that only the sentence that's challenged would be affected on resentencing. And so from those three options, from a constitutional perspective, what are we trying to figure out what the answer is? Is it that the CPC prohibits, it affirmatively grants, or are we looking at it from this holistic practice, case law, CPC sort of model? So
I think that in my view, the primary consideration should be the text of Florida's sentencing system. And obviously in a case where it's not affirmatively granted, I don't think it necessarily prohibits it. Now, I do think that there is a relevant strain of case law from the federal cases, right? Because in Florida, many of the courts believed they were bound by this court's decision in Fazenmeyer. We think that it's clearly erroneous, but they still felt bound, so they had to apply it, even if they thought it was wrong. But in the wake of Fazenmeyer, the federal courts started adopting the package model, court after court after court.
And from a text, go ahead.
Is your answer to her question, though, that your kind of inferences from the structure of the text kind of trump, in terms of deciding what the reasonable expectation is, that the reasonable expectation that I would get from making inferences about the structure of the CPC trumps the culture sort of path 3 that she was talking about?
Yes, I think one, because obviously the CPC revolutionized, or the multiple guideline systems, and then the CPC revolutionized Florida's sentencing system. And I think taking that in light of how federal courts have adapted to the sentencing guideline system, I think a person looking at the legal landscape, seeing that every single federal court is unanimous on this point after they adopted the guidelines, and then looking at Florida's system, I think that they could infer both from the text and how things had developed in the federal system.
So that, but I mean, it seems like the text, you'd have to be pretty strongly persuaded that the text had reached that there was kind of a certain kind of level of compellingness to the inferences that you would draw to overcome. I mean, you're not really disputing this kind of point about the culture and practice in Florida, and that's been going on for a long time.
I think that the practice can be helpful, but I think there's a lot of reasons why.
It's just kind of strange to tell someone, because this is weird, this reasonable expectation, it's just kind of strange to say that the practices and the logic in the federal case law would trump like what's been going on in Florida for decades.
Right. Your whole argument does presuppose that there is a difference between what happens in the federal world and what happens in Florida, right? So we shouldn't just walk past that. It's a matter of fact that this expectation exists. And what I hear the chief asking is, okay, so is that located in something that we should upset when it's the legislature's role to set such a policy or not? That's, I think, what we're getting at.
Right, and I think that inference can be drawn from the text of the CPC. I mean, that is our principal argument. But to the extent that practice is relevant, Your Honor, I would say that that practice has to be taken in light of the full range of legal circumstances that the.
Do we know the practice, though? I mean, do we know that that currently on resentencing, that judges are not assuming that they can resentence on all counts where the LPS was off, absent like a mandate? I can see, in the appellate system, right. If it's coming back on a mandate, it says resentence on count 1, which I think you could see, even if we decided this case in your favor, that would still be within the appellate court's discretion to narrow a mandate. But how are you? I guess maybe let me ask it this way: are you conceding that it is the practice in the state of Florida that everybody on resentencing, absent a narrow mandate, is resentencing only on the count that was challenged versus the entire all counts at issue?
Answer. So, Justice Sasso, I would say that we don't concede that is necessarily practice. Obviously, this case provides an example. I do know that there are cases where the DCAs apply Fazenmeyer, but I don't know that it's a universal practice. We haven't looked into whether this is a universal practice.
We just don't have that information.
Yeah, we don't have that information before you today. I
have kind of some practical questions about if we adopt what you've proposed today, how this would look. The certified question says, can they resentence on everything to comply with the law or to effectuate the intent of the sentencing court? Do you think that under your model, they could, for any reason, reopen all counts and sentence, just at the discretion of the judge? Can they make it significantly worse? That there was an invalid sentence to begin with, and as we have in here, and it's not really about the intent.
Certainly, we don't think a trial judge's subjective intent is what the best way to run the railroad here.
Okay. So what limitations would be on the resentencing judge in how the resentencing scope?
Yeah, so I think that is, if the court does adopt that approach, it's going to have to address those questions when they come up. But my inclination, based on what...
Well, if we adopt that approach, we're about to open up everybody for resentencing on every count. We have to give some level of guidance as to what that entails. So what would be the state's position on that?
Well, I'm not trying to dodge the question. My inclination is that it might be best to give the trial judges some level of discretion to decide whether they're going to reconsider just the count or conviction, the sentence for a conviction that was vacated and perhaps retried, or to open up all the counts.
Okay, so if they open up all the counts, it's a new resentencing judge, can they give a lower sentence?
That's perfectly fine.
So if the state's position is new judge, new resentencing, they can give, as long as it's within the code, it can be any type of sentence, completely open.
Yeah, the CPC tells us to punish, I think this is another piece of textual evidence I think is relevant, to punish the offender.
Okay.
Right?
And at a new resentencing hearing, it's de novo, correct? I mean,
yes.
So if in the state's model, if it is reopened, then the defendant is entitled to a completely new sentencing hearing and to present any new evidence, anything else. So we're saying for all of these cases that go back, the trial court now will conduct a completely new resentencing hearing as if the first one never happened.
Right, like what happened here, yes.
Okay. And my final question is your position the same if the state appeals the sentence?
In other words, if we appeal the sentence, the trial judge could reopen all of the...
Yes,
yes, absolutely.
There's no finality even if the defendant chooses not to appeal.
That's a harder question, Your Honor.
Because if we adopt it as a package model, then it shouldn't seem to make any difference.
I don't think that it... I think it... That's a tough question, Your Honor. My inclination, I don't want to give a binding position for something I haven't fully considered, but my inclination is it may be different, again, because the double jeopardy clause looks to the legitimate expectations of finality of the defendant, and typically in a package model, in the package model cases in the federal court, they say, well, when a defendant voluntarily reopens his package. I'm not sure what would happen in that instance, to be honest. It may be different.
Thank you.
Okay, you can have 3 minutes.
Thank you, Your Honor.
And if you need a little bit of extra time. Yeah.
Thank you, Your Honor. May it please the court. My name is Nick Shanine, and of the Shanine Law Firm, and together with Bill Pinal of the Pinal Firm, who by appointment of this court represent the respondent, Michael John Phillips, would address the issues before the court. Mr. Pinal will address the constitutional and statutory criminal law framework issues that this court has addressed. My only role here in a limited time will be to provide this court any insight regarding the appellate practice threshold question, which Justice Curiel referenced with regard to the fact that the state did not appeal the second count.
So on that issue, and I'm assuming you're talking about the waiver argument.
That's correct, Your Honor.
It was a separate proceeding that the state now kind of has an argument that they could not have made when the original sentence was imposed. And so how is that a waiver if the idea is that you have to raise the argument at the earliest opportunity? I think the argument is that on resentencing, all counts should be resentenced. Why are we looking at this from a you didn't appeal that sentence?
And the answer, Your Honor, is that the issue that they want to raise would certainly be appropriate. The problem is that you can't change the facts. The case law of this court, the Dade County School Board versus WQBA case that talks about the tipsy coachman principle, says that you are allowed to raise any issue supported by the record, but you can't undo the record itself, where if you fail to appeal or object to this second count, even if later analysis says, oh, that turns out that was improper, that means that is now frozen. And that's this court's case law in Gartrell.
Does this argument kind of depend, though, on it not being a package sort of sentence model?
There is, while we would disagree that the two sentences are intertwined, we would agree that these two issues are intertwined, and that's why I'm about to pass the baton to Mr. Pennell to answer that part of the question.
So in other words, if for some reason the majority of the court determines it's a package model, the waiver issue doesn't really come up because it would have been reopened. It would have been an argument that could be made in a de novo sentencing context anyway.
And of course, as Chief Justice Muniz has noted, it's important that the rules of the game should have been known to the parties as they did that. When he appealed only the first count, or questioned only the first count, and the second count was not appealed by him nor by the state, that's why those facts matter. And that's why we believe the threshold matter of waiver does exist if the court elects to use it. However, these other
on that same argument, and I don't know if this is necessarily relevant, but the defendant also did not appeal the sentence when it was opposed and then came back on a 3800B motion.
And that's the case law, again, under Gartrell says that's the way that the process must work. The defendant is allowed to do that. The state, if it wanted to challenge, does not have that remedy. It must appeal, and it chose not to. And that which was done is done, and that is the point of the threshold waiver issue. With that, I would like to ask the court to hear the argument of Mr. Pennell regarding each of the important double jeopardy and statutory issues.
May it please the court. It's our position that this is a legislative issue, and this court has repeatedly examined the plain language of the sentencing statute, starting with Fastenmeyer in 1984, followed by Moore, and most recently in Gabriel about 4 years ago. And each time, this court has concluded that the plain language of the statutes indicate that sentences for each conviction are not interrelated.
Well, and this is one of those, I want to avoid the bumper sticker. Of course, they're interrelated in the sense that the score sheet uses the total offense, computation. The state's right about that. But you reference Gabriel, and Gabriel is significant, but it's obvious that it doesn't answer today's question, or else courts would just be citing Gabriel. So what I'd like to sort of drill down with you about is why is it that Gabriel doesn't answer our question today? And I think it has something to do with the fact that we're here on resentencing. It is in some respects a de novo proceeding, and the question is what kind of finality interest your client, the constitutional question, we'll come to the statutory question in a minute. The constitutional question is what kind of finality interest does your client have in a sentence that, I mean, you're kind of like whistling past the graveyard. You know the sentence was lower than the lowest permissible sentence. You don't appeal it. But does he have a finality interest in that sentence, even though it should not have been given? That's, I guess, my first question.
And the answer is, I think you go look at D. Francesco from the United Supreme Court, and they say that the defendant doesn't have an expectation of finality until the state's appeal, or the government's appeal in that case, is concluded, or the time to appeal has concluded. And in this case, the state chose not to appeal. So once they chose not to appeal, he had a reasonable expectation of finality.
Even if the sentence is illegal?
Illegal might be different. This is not an illegal sentence. This is an invalid sentence, because there could have been a downward departure if there was a basis. So the sentence, it would be different if there was it could be different if there was a minimum mandatory that was required to be imposed, but this was within the court's discretion to impose. And because it's just invalid. The defendant had a reasonable expectation of finality once the state chose not to appeal. That in Florida's system, there's no rule or statute that gives the state the ability to challenge a statute.
I think
after direct
DeFrancesco,
appeal.
though, it didn't focus it on, the appeal. It's trying to determine whether an appeal is similar to an implied acquittal. It's trying to work in the issue presented, which was an appeal in that case, into the overall double jeopardy framework, which is this structure an implied acquittal for the purposes of double jeopardy. And so I don't think we need to get caught up in, is it an appeal or not an appeal? We're trying to see whether, under the CPC, whether somebody who challenges something on the 3800B ends up with resentencing, whether that's an implied acquittal under DeFrancesco, rather than skipping that step and going to the.
But I think, as the other justices have noted, I don't think there's any indication in the CPC that indicates that the state has the ability to challenge a sentence other than by direct appeal. And
yeah, so then we need to look to the CPC to see whether the defendant would expect, if he challenged a sentence, whether the other sentences would be opened up on resentencing. So I agree with you that we should look at this from the defendant's perspective rather than whether or not the state appealed. I'm just not sure how whether or not the state appealed is relevant to that question of the defendant's expectations.
Well, I think this court and I think the U.S. Supreme Court in DeFrancesco, I mean, there was dispute between the majority and the dissent. The dissent thought that the sentence could never be increased based on a government appeal. What the majority said is it's okay, it's not a double jeopardy violation because there's a finite period for the government to challenge it, and then after that there's a reasonable expectation of finality. And because from the defendant's perspective, he knows, because he's charged with knowledge of the law, that the only way the state can challenge a sentence is on direct appeal.
Yeah, so then it does kind of come down to the package issue. I mean, on if it's about the only way that this sentence can be challenged is by the state. Right?
And when you compare the Florida statute 775-021 subsection 4 and 921, there's repeated indications that each count needs to be sentenced independently and have a discrete sentence. When you read 3553, U.S. 3553, it talks about a singular sentence.
Can I ask you about some of the other similarities? So one of the questions earlier was about the similarity between Florida and federal law on the specificity regarding resentencing. And if I understand the federal structure correctly, the sentencing guidelines don't explicitly state directions for a court on resentencing, right? In other words, it doesn't explicitly say on resentencing you can resentence the entire package, et cetera. The federal courts have been interpreting essentially what our CPC would. There's no direct.
I think the only
no direct authority for the federal courts.
I don't think there's a direct authority on resentencing, but when you read the general statute on sentencing, 18 U.S.C. 3553, it talks about a sentence as a singular package, as opposed to 775-021.
So in other words, our enterprise is the same. We're looking at not for direct authority on resentencing. We're looking at the CPC, just the sentencing structure overall, to determine whether this would be. And then what would your answer to that be? Either granted, the authority explicitly granted, or prohibited by the code from a statutory standpoint?
Well, I think by the legislator, by stating that there has to be discrete sentences, is saying that there isn't a package model. So I think that's the only textual context we get. We certainly don't have an indication that the trial judge is prohibited from doing this, or the trial judge is prohibited from doing it. But we do have an indication, an explicit indication, that's been there since Fassenmeyer, that there's distinct sentences for each count. So I think that language, and if this idea that the federal system is doing it differently, Fassenmeyer decided in 1984, if the legislator wanted to make it clear that this was a packaged model, they would have done it.
How do you define packaged model? I think your friend on the other side used the word intertwined, which I find a helpful framework. There's no federal test, on the case law for determining what's a package model and what's not in the states. What test would you use to determine whether something is a package model?
I mean, I think you look at the statutory language where they say impose one sentence as opposed to distinct sentences for each count. So the package model would be, if the Florida statute tracked 3553 more closely, then we'd be in a different position. But anybody that's been in federal court and done a federal case knows that federal sentencing is this is apples and oranges. This is way different. And again, that the statutory language is in complete conflict. One talks about sentencing in the singular, and the other explicitly says separate and independent sentences.
So if we were going to write an opinion favorable to you, one thing, if the majority is persuaded on this statutory thing, we would talk about that. But then this other aspect of sort of the practice in Florida.
Sure.
How concrete, like what can you give us that's, more than just this kind of, general sense or feeling or perception? I mean, what would one point to establish the notion that we're sort of disrupting kind of a settled status quo by sort of declaring now that there was never a reasonable expectation?
You would look at Fassenmeyer, you would look at this court's decision in Moore, and you would look at this court's decision in Gabriel, and in each and every one of those cases, this court indicated that there was separate and distinct sentences.
To me, that doesn't really get you. I don't know that gets you.
I think it does,
all the way that you want to go.
I think it does, because I think the legislator then has the ability to react to those decisions and say that's not what we want. So, and Moore explicitly tells everyone under the CPC, the offenses are not interrelated. One score sheet, but multiple sentencing ranges. So
I think
that gave the legislator go ahead.
Well, I think just to follow up on that and what came up before, is this, in the DCA world and in trial court world, is this something that is happening? Are they resentencing all the time on all the counts? Are all the courts feeling that they are bound to only resentence on the count that was on appeal? What is happening in the practical sense?
Personally, I've had both. But I've certainly 2 years ago lost a case in the 5th DCA where I got a de novo sentencing, and the 5th DCA said no, that wasn't appropriate because your client only challenged these 2 counts, so you can only get resentencing on those 2 counts. So that's the current state of the law.
Also from a practice.
Don't we really have to look at what the cases show, right? And am I correct in understanding that the state really doesn't have any case law that directly supports what they want to do, whereas you do have case law that directly supports? Is that correct?
Yes, I believe Fassenmeyer, Moore, and Gabriel fully support our argument, and if the legislator wanted to change it, they've had.
Well, is there anything in the case law that directly supports what the state is asking us?
Not that I'm aware of, Your Honor.
And I'm talking about the state case law. Obviously, they can point to the federal stuff, but
not that I'm aware of, Your Honor.
Can I also sort of explore with you the extent to which the textual clues that the state was identifying? I'll start with 775-021. Support or don't support your position or the state's position. So 775-0214A says that whoever in the course of one criminal transaction or episode, so it does identify we'll call it a package for now, one criminal transaction or episode, commits an act or acts which constitute one or more separate criminal offenses, upon conviction and adjudication of guilt, shall be sentenced separately for each criminal offense, and the sentencing judge may order the sentences to be served concurrently or consecutively, period. Okay. What work does the word separately do in that sentence? It appears twice. There's separate and separately. Given the fact that the sentences may be served concurrently or consecutively, what work does the word separately there do? If I'm able to give a separate sentence for each count of conviction and yet modulate the total length of someone's time in state prison, what do you think the legislative bargain is or that is reflected by the use of the word separately there? What work does it do in the statute?
It makes it clear to the judge that each crime must be sentenced separately or distinctly. It doesn't matter that it's in one episode. I mean, it used to be that if there was an argument that if there were multiple victims in a DUI manslaughter, you could only get charged with one offense. What this language has been interpreted to say is, you know, if one course of conduct results in multiple crimes, you have to give a separate sentence for each.
Okay, so that, when I look to Rule 3.700, the definition of sentence, the term sentence means the pronouncement by the court of the penalty imposed on a defendant or the offense of which the defendant has been adjudicated guilty. So again, it speaks to a singular offense.
Right.
Okay. Given that, the next question becomes, what about on resentencing, right? So is there a textual basis for your position, or is it just essentially a due process once we get to the resentencing part? Because I'm with you so far.
The only textual base, there's no, I'm not aware of any direction or statutory language that talks about resentencing specifically. All we know is that the statutes regarding sentencing talk about independent and distinct sentences. So I think that's the only statutory text that addresses this.
But the federal sentences are separate, and I mean, we're sort of chasing ourselves around on what's a package or whatever. But I mean, if you're just if all that, really all that the word separately does is just to say that you're going to enter a sentence for count 1, count 2, count 3, whatever, that's the same thing in the federal system, right?
No, but this court has interpreted that to mean that the lowest permissible sentence is for each offense.
Right. And that's fine. That's extremely relevant at the moment of sentencing when you're trying to decide what to do. But all this stuff about what happens on remand and when I challenge one, do I put all the others in jeopardy? That's just seems to me like a completely separate question that's not really answered. I don't see it as a textual thing. I mean, that's why, to me, it seems like maybe I don't know what cases you look at or the practice or whatever. It seems like what they're asking to do is to sort of change sort of the norm.
Well, we know the practice based on this court's decisions, and the law has been that if the defendant doesn't challenge one count, if he challenges count 1 and not count 2, then count 2 is not subject to being changed.
We talk about the practice at sentencing, though, from an intertwined standpoint.
Sure.
Would you agree that the package of trial courts, when they're imposing the original sentence, whether they're going to run something consecutively or concurrently, the range within the allowed sentence that they're going to pick, do most courts do that with an eye towards the overall sentence?
I don't know what most courts do. I know that Gabriel tells them now that they need to do it independently. So the
CPC is certainly structured, though, to allow a court to do that, right? I mean, the court has discretion to kind of say, all right, I think the crime was this bad. I'm kind of looking at 30 years overall. I'll run these 3, consecutively as a result.
Certainly gives the judges discretion to make that decision. But again, I think the most important part is this court has consistently interpreted the language to say that there's separate and distinct sentences all the way back from Fassenmeyer through Gabriel. If the legislator
and do you want to address the state has a section in their brief, inconsistencies with other case law, and cites Blackshear, a recent 3rd DCA case where the court said that the entire package, so to speak, could be resentenced.
In all the cases that the state cited in support of that argument, it appeared to me on their appeal they challenged both sentences. So there wasn't any question about whether one or the other could be handled on resentencing. It looked like either the defendant or the state had challenged both sentences. So the defendant didn't have a expectation of finality because he was challenging or he knew the state was challenging both. I don't think the state has cited a case where, similar to here, where only one was challenged. For the reasons we've argued, I'd ask that you approve the decision of the 2nd District.
Okay.
Thank you.
Thank you.
Just have a few few points.
Would you respond to that last point? Is he correct in what he said about your cases?
I am the specific posture of Blackshear is escaping me, but I do know that
I'm sorry, I didn't understand what you said.
Sorry, the specific posture of Blackshear is escaping me at this point, Your Honor, but I do know that in Fazenmeyer, where the defendant challenged the sentences, this court said about another, so the holding about the package model they brought up in count 3. In count 2, this court said the court would have been free to change on remand about the second count from concurrent to consecutive as long as it stayed within the guidelines of Pierce. So that, I think, says that the court can change the overall sentence on remand. It can change it from concurrent to consecutive, Your Honor. And so
that sounds dicta-ish.
I mean, that at least based on what the text of the Blackshear and the DCA case that we cited, I know that they thought that language implied that they could do that on remand. I don't want to rely on dicta-ish, but I just want to bring up two limits, Justice Grosshand, to what you said. First, when it comes to the discretion that a trial court might have to reopen, I think it's important to note that I expect, and you could instruct courts to consider how an appeal might affect those other sentences before exercising their discretion to reopen the entire sentencing proceeding. And of course, vindictiveness is always going to be a protection, a limit on a district court's or a trial court's ability. I apologize. A trial court's ability to re-sentence in certain ways. And then when it comes, Justice Sasso, to your point about the holistic nature of sentencing under the CPC, my understanding is that nothing prohibits a judge from acting holistically, thinking about the sentence at the end of the day. And in fact, I think that is the command of the CPC, because in its principles, the CPC says the primary purpose of sentencing is to punish the offender, not just consider the severity of the offense, which it has in another portion that they are also supposed to consider. To me, I read that as saying the job of the trial court is to sentence not just the crime, not just fit the punishment to the crime, but also the criminal. And as far as
what do you say though to someone like me who is skeptical from the out, who thinks that maybe we got off on the wrong foot, even under pre-CPC, and that it was misguided not to have sort of viewed it as a package for the very reason that you say, that it's just common sense, but that there's been this long kind of understanding in our state that that's what we do, and that creates the reasonable expectation. It just, my problem is that we're sort of having to go, given the nature of the test, it'd be different if we're trying to kind of try to find the, the quote unquote objective meaning of some written thing. But now it's like we've sort of set the rules of the game, arguably, through the practice that we've had in this state for a long time. And the question becomes like, how do you change the reasonable expectation? It just seems like the better approach would be for the legislature to directly address that. And then they could also kind of fine tune. Maybe they want them reopened in some cases and not. Maybe only when one of the others is, unlawful or whatever. I mean, you know what I'm saying? We're going to kind of having to be making it up on the fly. So how do you respond to that?
I have two responses, Your Honor. So first, well, let me survey the responses. So the first is I would say that I don't think that case is binding on you because of the changes in the statutory nature of the system. And I think that has to impact. The changes in the text have to impact, or at least when we identify material changes, have to impact the expectations.
Which material change?
So I think the creation of the LPS, Your Honor, I think the directive at the beginning of the CPC that tells them to focus specifically on punishing the offender, and I do think that the concurrent consecutive distinction, while it existed before, if you don't believe that Fazenmeyer...
But isn't it true that none of our courts have recognized what you're saying? I mean, you're saying it had to change it, but it doesn't seem to have changed it, has it? I mean, but the Chief's point here is that all this is intertwined because you've got this expectation that has to be based on what courts are saying and the way the courts are understanding these things, not based on what some uber textualists might come up with. So what am I missing there? I mean, because I don't see how you get around that.
Well, Your Honor, I do think that if the legislature completely overhauls the statutory system, I mean, we're always going to have to interpret that system for the first time. And I understand.
But again, this didn't happen yesterday. Okay, you're talking about changes that went on when I still had hair on my head. I mean, this is a long time ago. I just and then but the courts have been dealing with it, but not in a way that appears to me to support your position. And I don't think that you're not really pointing to anything that Florida courts have said that support what you're saying about how this change in what a sentence defendant could legitimately expect about the finality of a sentence would be.
Well, Your Honor, I mean, again, I think that it takes time for these issues to percolate. I mean, the case that I identified from the 11th Circuit, Fowler, where I talked about the pre-guideline sentence, I mean, that was pre-guidelines to 2014 before that issue finally came back up to the 11th Circuit. So I think that the job now is to take a fresh look at the CPC and approach it as a text and ask what it means.
Okay,
and then,
you can have 15 seconds to finish up.
Thank you, Your Honor. I would just say that the other opportunity, you may consider that this defendant, Mr. Phillips, may have an expectation of finality, but to address the CPC going forward, that may be another possibility. So thank you, Your Honor.
Thank you. The court's going to be in recess for 10 minutes. Thank you.
All rise.
I got one in the armory.
All rise. Supreme Court of Florida is now in session. Please be seated.
How's everybody doing?
Yes.
Yeah.
We were just going to affirm and leave, so I'm glad you came up.
Apologize.
Hold on. Are you ready? Are you not? Okay. So our next case here is Stallworth versus State of Florida, number 2024-0584. Go ahead.
May it please the court, my name is Victor Holder. I represent the petitioner, Mr. Stallworth. I'd like to reserve 6 minutes for rebuttal, please. We're here because Mr. Stallworth was entitled to an instruction on the affirmative defense of duress at trial, and he was denied that instruction. He was entitled to the instruction because there was evidence to support the defense at the trial, and it was a valid defense to the charges of felony murder.
Would you kind of go through the evidence that supports the giving of the instruction?
Yes, and I think the most important, all of the evidence came through defendant's statements made in 3 separate interrogations with law enforcement that the state put into evidence at the trial. And so the most important, probably the two most important statements that Mr. Stallworth made come from page 387 and 388 of the transcript. And the most important is he says, if I had turned around, meaning if I had not continued with the robbery, continued to the shed with the robbery, if I had turned around, y'all would have 3 bodies right now, meaning him and his girlfriend who was the driver of the car. So again, his body, the girlfriend's body, in addition to the deceased. So right there, he's expressing his fear that if he didn't go forward with the robbery attempt, or the robbery, that he would have been killed and his girlfriend would have been killed.
So the evidence is the subjective understanding that Wild Bill is a dangerous person and would have killed him, not, for example, an actual present, objectively observable thing like I'm holding a gun to your head.
Correct. It's Mr. Stallworth's belief, based on the circumstances he's in and his experience with, I believe it's Miles was the co-defendant. Wild Bill was another name mentioned, but I think Miles is the one that he's speaking of.
He's afraid of Miles.
Yes, and so he believes Miles will kill him. He states that, and then there's other statements that he makes during the interrogations that inform the reasonableness of that belief. He's been with Miles before. He's seen Miles get very aggressive and violent when he's high on drugs. Miles was high on drugs that night. He's seen Miles hurt people. That evening, he could see that Miles was serious based on his demeanor and look on his face. Miles was armed. According to Mr. Stallworth was not armed, and we must remember that we take the evidence in the light most favorable to the defendant when we're analyzing whether or not they get the defense instruction. He was outnumbered by the other 2, by Grice and Miles, as far as co-defendants go.
I had to come up with a theme for the defense here. It would be perception is reality.
Correct. And
but let me ask you this. I mean, at the very beginning, when they got there, your client observed this person pistol whip somebody, and then he told him to put on the ski masks. Your client apparently was a bit hesitant, and he looked at him and said, I'm not kidding about the ski masks. And your client, I believe, testified, he gave him that look that only he could really understand what it meant. And that's, to me, that's the one crucial, from my perspective, one crucial factor that I think the first DCA left out, their opinion. And that's where it began.
I agree with you. He hesitates to put the mask on, and he as you said, as your Honor said, the co-defendant states, "Man, I'm serious," and he's got the look on his face that Mr. Stallworth is in a position to interpret. He's right there in the circumstances, and just like a self-defense defense, we judge it based on the circumstances that the defendant is in, and then it's for the jury to determine whether or not it's a reasonable belief that
giving this instruction, just to step back for a second and look at this through the lens of first principles, whether to give this instruction is a matter of the trial court's discretion, right? We're reviewing for abuse of discretion.
We are reviewing for abuse of discretion, but it is long-standing Florida law that a trial judge's discretion is much more limited in this situation where a defendant is requesting a defense, a sole defense. If there's any evidence at all to support the defense, the trial court has to give it. The defendant is entitled to the defense, so it's a limited discretion.
Can you lay out what the test has been, sort of traditionally, notwithstanding how the first DCA explained it in your case, but what is the trial judge supposed to do?
The trial judge is supposed to do, according to many cases from all the different districts and from this court, that if there's any evidence at all to support the defense, then they're to give it. It doesn't matter if the evidence is weak. It doesn't matter if the evidence the evidence of the defense conflicts with all the other evidence from the rest of the case. It doesn't even matter if, and let's say as it is here, the evidence is based on the the defendant's statements. It doesn't even matter if the defendant's statements conflict with other defendant's statements, with his own statements. If he's got problems with credibility, it doesn't matter. If he's
So it's not really a case in which the trial judge is typically looking for credibility, weight, quality. They're looking for sufficiency only.
Correct. They are not supposed to, the trial court is not supposed to weigh the evidence when it's making a decision whether or not to give the defense instruction. And the appellate court is not supposed to weigh the evidence
And what
as
in
well.
particular do you think the first DCA did that is different than that?
Well, putting
In their
aside,
analysis? Because we're here kind of on a conflict, that we're not here just because you think your client
correct.
they were wrong, but it's a conflict. And so what do you think that they did that conflicts with this particular longstanding body of law?
Well, I think the first district's opinion actually conflicts in 3 different ways. First, they require the danger facing Stallworth to be real, and they don't even allow for the alternate possibility, which Hall, the Supreme Court case, Hall says that a defendant can reasonably believe that he's facing imminent danger. The danger need not be actual.
So they're looking at the weight or the quality, the weight of the evidence.
Yes, and so then the second way that I think the first DCA's opinion conflicts is that it makes a statement that a defendant's self-serving statement alone that conflicts with the rest of the evidence will not sustain or will not be an abuse of discretion if they deny the defense based on that. But there's countless cases, and I cited to many of them in the reply brief, where just that happened, where the defense was based solely on statements made by the defendant, and the trial court didn't give it, and the appellate court said it's an abuse of discretion. Any evidence, all, including just statements that conflict with evidence, entitle you to the defense. And I think
the bottom line, I'm sorry, it was a third one.
The third way I think it conflicts is that the first district seems to require a direct threat or an overt threat from the co-defendant in order to justify the duress instruction. And the law does not require a direct threat or an overt threat. It requires danger, real imminent impending danger, or a defendant's reasonable belief in that danger. I think a good analog for the duress instruction is self-defense, because it relies on the perception of the defendant in the circumstances he's in. He has to perceive a threat and make a decision, and that decision is then, the reasonableness of that decision is then judged by the jury.
Go ahead. I'm sorry.
No, go ahead.
I think the bottom line is basically that it's a very low bar when it comes to allowing these defenses, instructing on these defenses. And the way I'm reading the first district's opinion, it just seems to me like they're looking at it like elements of a crime. And if the element is not there, then we grant a directed verdict or judgment of acquittal. Here, you did not act, the buzzwords didn't come out that I was scared because he threatened me or whatever. That didn't come out, therefore, he didn't prove it and it's excluded. So that's what I think the bottom line is.
Well, I agree with you. I think it is a pretty straightforward. I think it is a very low bar for the defense to get, for Mr. Stallworth to get the defense. And I think the first DCA weighed the evidence improperly.
So I apologize if this is a dumb question, but can you just help me from a rules of evidence perspective how this kind of uncross-examined, because I understand the statements against interest thing and everything, but this business about, the prior history with Miles and all that stuff, I mean, how, being put in for the truth of the matter asserted, I mean, how does this, can you just help me just walk through how this is, how it's actual evidence?
This came in because the state put it into evidence. It wasn't Mr. Stallworth did not put it into evidence. The state introduced these recordings into evidence and published them for the jury. There was no issue as to their admissibility.
But what hearsay exception were they traveling under?
Well, statements against interest, I would assume, and then I would also assume that the state would put it in there for 2 other reasons: to prove the credibility, or for credibility purposes, because Mr. Stallworth makes conflicting statements within those different interrogations. And I'm also assuming that the state put it in there to prove that he was at the scene, because they did charge him with felony murder.
So this business though about Miles and their history and all that, I mean, so you guys don't have any obligation to, because that aspect of the interviews doesn't itself fit within any kind of hearsay exception. So how is that even properly under consideration?
Well, the state put it in evidence and nobody objected to it, number one. Number two, the entire conversation provides context for the statements. So as far as he's saying he's scared, that's why. If you're asking what obligation the defense attorney has to not put evidence or not put the statements in, I'm not sure.
Okay. Yeah,
I'm not sure why a defense attorney would want to not have those statements in.
It just seems like if you want to, this whole thing should be. I know that arguably you can't kind of separate it from the stuff that is subject to the hearsay exception, but I mean, a lot of this is really, I think part of what maybe was troubling to the first DCA is that it's just there's no, there was no opportunity. The issue, the state's interest in this wasn't this Miles business and whatever, and that's not the relevance of it. And I don't think that they were introducing that part to get to the truth about how scary Miles was, obviously. Now it's kind of being used for a different purpose. It seems like if the defense wants to use it to establish all this other stuff, then it should have to be subject to cross-examination or subject to an exception, which it's not.
Well, I'm not sure why the state would be able to put something into evidence and argue one way, but then the defense would be prevented from arguing the evidence that's been admitted.
I guess it comes down to what it's for. You know what I'm saying? But anyway,
I understand.
Don't worry about it.
Once it's in, and that's the case that's brought. That's where we are.
Well, no, but I mean, statements get put in, and they are objectionable or not, depending on what purpose they're being used for. And so at the time that the state is putting it in, they're not being used for the purpose that you're using it. So maybe they should have raised this before. I was just trying to get my head straight on how some of this is even on the table, because it's inherently kind of not super credible, and obviously we have ways to kind of determine how credible it would have been, which would have been cross-examination, et cetera, et cetera. That didn't happen here. I was just curious about that.
And certainly the state is free to argue the credibility problems on closing to the jury once he gets the defense.
Well, and the state had other witnesses too.
Yes.
That were not entirely consistent with some of the things that the defendant is saying in these recordings. So, but the state puts on its case, okay, and you're here to simply about whether the defendant could have the jury instructed on a defense, which was like all he had.
That was his defense, and that was his sole defense. There was evidence to support it. It was a valid defense to his charges. That's where we're at.
What evidence supported the determination that Miles was going to direct violence towards him? So in other words, was the evidence just that Miles is a scary person, or was there evidence from which a jury can conclude that he was going to actually experience violence or danger other than Miles just being scary?
The evidence comes from the defendant's statements, which were put into evidence, and the original statement is, I feared him because there would be 3 bodies if I didn't go along with it, essentially, page 388. It's the other things that the defendant says in the statement that the jury can reasonably infer that Mr. Stallworth believed that he faced danger.
But you would say in this particular case, there's no, even assuming in the light most favorable to Mr. Stallworth, there's nothing that showed that Miles directly threatened him. He was just a violent person in general, was kind of the understanding. There wasn't like, oh, he's threatened me before, he's, told me if I didn't do this, he would kill me. There was nothing like that, which is often kind of what we would see in that type of thing.
Right, so he didn't verbally threaten him. That's accurate. But you don't need a direct or an overt or a verbal threat. And jumping quickly to self-defense, you can, Mr. Stallworth has witnessed Miles be violent in the past. That's something that you can take into account when you're judging a self-defense case. Has that defendant seen the violence of the victim in a self-defense case before, and that informs his reasonableness, the reasonableness of his decision.
It's something a trial court can take into account, right? Like, that's part of the reason I go back to the standard here. I mean, there is evidence that Miles gave him a look, right? That's basically the best answer you have to Justice Grossan's question, is there really wasn't a direct theft, but he did give him a look, and now this sounds really like a determination a trial court should be making.
Should not be making.
My point is that this is, I think, a core illustration of why trial courts have discretion to give or not give instructions, and I'm having a hard time seeing how the decision not to give the instruction, having considered these things, was fanciful, arbitrary, or no trial court would reasonably give this instruction.
And that is the wider discretion standard. But in these cases, discretion is much more limited.
You're going to have to help me understand how those two things are true, because it is the case that this is an abuse of discretion standard. You're right that other cases have recognized that when there is this 6-part test, and that exists for a reason. In other words, we wouldn't have a need for that analysis if, as you suggest, the right answer was, if there's even a scintilla of evidence of threat, then the duress instruction must be made.
Well, first, the defendant has a constitutional right to present a defense.
Yes, but this is about a jury instruction.
Well, that is one of the reasons why the discretion is more limited, because if there's any evidence to support his defense, he has that right, a due process right, to present his defense to the jury. So that's one reason why there's a more limited discretion. And the 6-part test, which the 6-part test that came from the jury instructions has its own issues and has since been replaced with a new jury instruction that I think more accurately reflects the state of the duress law, and that more accurately tracks the language from Hall and the other cases that have discussed duress pre-jury instruction.
But the key thing about whatever the test is, in deciding whether to give the instruction, the judge doesn't have to go through and weigh it all and think whether he thinks it is a good defense. I mean, that is absolutely not what the judge does. Under our law, the judge has to decide whether there's something that would tend to support that defense. Isn't that correct?
That's absolutely correct.
And we've got a big body of case law. So that's the role of the judge. And so the discretion has to be understood within that circumscribed role that the judge plays, which is not to go through and decide to weigh the different parts of the test at all.
Absolutely.
Correct?
Absolutely. Is there evidence to support the defense? It's very similar to when the state faces a judgment of acquittal motion. If they've put forth a prima facie case, if there's any evidence at all, it goes to the jury. It's not a situation where they weigh the evidence there, where they say, oh, the credibility of the state witness was terrible, we're going to grant the judgment of acquittal. Even if the worst witness in the world, credibility-wise, gets up there and lays out the elements of the crime, it goes to the jury. The jury then makes the determination. So it's the same thing here with the defense. The trial court doesn't weigh the witness testimony, doesn't weigh the weight of the evidence. It just looks, is there evidence, and then it gives the instruction if there's evidence and it's a valid defense. And I would like to return quickly to the kind of the overt threat, act portion. In reading through the Gonzalez case, which I cited in the reply brief, in the Gonzalez concurring opinion, there's a case called Radler, R-A-D-L-E-R, 290 Southern 3rd 87. And that says that no overt act is required. Now, this is in the self-defense context, but again, very similar defenses. No overt act on the aggressor is required to get the defense. And the Radler case cites to Chavers, which is another first DCA case, where the circumstances surrounding the defendant, even if there's no overt act, the circumstances can all add up to he felt fear, reasonable fear.
Yeah, and overt is obviously not in the jury instructions. We will, but there is, imminent and impending perceived harm, that sort of thing. So it does suggest something other than like some knowledge that this person has been violent.
No, yes, correct. It requires a real, impending, imminent danger or a reasonable belief that he faces real, impending, imminent danger. And
so when
objectively reasonable?
Objectively reasonable,
right.
Yes.
And so I think the question is getting at the idea that you've got to kind of look at the evidence of what was going on that's kind of there that you can objectively evaluate. And the question is, does just an assertion that this person has been violent in the past, does that meet that test? Is that the wrong question to ask?
Well, I think the objective reasonableness, whether or not he was objectively reasonable in believing he faced this particular harm, is for the jury to decide. It's not for the trial court to weigh when deciding whether to give the defense. I think that's first and foremost. And I think...
But you're saying as a matter of law, someone's just past violence that's sufficient evidence to, because obviously the jury gets to decide whether I believe is this statement in the interview, do I believe that he was violent in the past, and then does that put me in reasonable fear? But are you saying that just as a matter of law that's enough?
No, I'm saying that his past violence is a factor that adds to the reasonableness of Mr. Stallworth's.
And here we have that factor
Yeah,
plus
what
big
else?
eyes.
I'm sorry?
We have that factor plus, he made big eyes at him, right? What else would there be other than that?
We had that factor, the prior history. He made big eyes, and he also was armed with firearms. Mr. Stallworth was not. He looked at him. He witnessed him pistol whip two other people who didn't act fast enough. He witnessed the violence. He's witnessed violence before. He knew that he was extremely aggressive and violent because he's on drugs that night. He was extremely high, according to the statements. So I think all of that adds up to evidence that informs the reasonableness of Mr. Stallworth's belief, which he says his belief. If I had turned around, you'd have two bodies right now, which is referring to him and his girlfriend. So he stated his belief.
That's the subjective part. You agree that there's an objective aspect to this?
I agree that's his subjective belief, and then those things that I've mentioned, the prior history, the drugs, all of that, it then is evidence of whether or not it's reasonable, and that is all, whether it's reasonable, whether it's objectively reasonable, is for the jury to decide after it gets instructed on his defense of duress. I think where the error was is the trial court improperly weighed the factors, and the first DCA did the same. I'll go ahead and reserve.
Okay, thank you.
Good morning, Mr. Chief Justice. Good morning, Your Honors. May it please the Court. My name is Charlie Lee. I work for the Attorney General's Office, and I represent the state of Florida in this case. Before I get into why Stallworth does not conflict with Hall, I'd like to talk about the objectiveness and the what Justice Curiel brought up. In this case, we had a subjective fear. Looking at the jury instructions, it talks about reasonableness. It talks about real harm. And courts should be allowed to look at the context of all the facts, not weigh the facts, certainly. But duress is not, the jury instruction makes clear, duress is not like self-defense at all. Self-defense is, we don't discourage citizens from defending themselves, but citizens do have a duty to abstain from committing robbery and to resist duress and to avoid it at all or avoid committing offenses at all cost. And that's why we have a jury instruction. And I noticed that this court's current jury instruction talks about what a defendant must do. There's a note there about a split between the Fifth Circuit and the First. But both the Fifth and First say the defendant has the burden of production to establish each element of the defense before the jury instruction is given. That wasn't done in this case. The subjective fear that Mr. Stallworth had, just because he's around a bad guy, and he never pointed to why Miles was that bad.
Does that mean that there was no evidence of duress?
Not of each element. Under the jury instruction, it says that he has the burden of production for each element of duress. Now there's 8 in the current jury instructions, but even the 6 Mickel elements.
But isn't that for the jury to determine?
Not if the defendant does not establish each element. Some evidence. Court shouldn't weigh it. Court shouldn't decide whether it's good evidence or bad evidence. Court shouldn't decide whether it's conflicted with other evidence. And as one
And he's
just
entitled to reasonable inferences from the evidence, correct?
correct, to give it context, like Gailey's
With
like
the jury, he's entitled for the jury to so it doesn't all have to be direct. It can be inferential.
it can be. In this case, there really is no evidence. I mean, Mr. Stallworth.
Well, I understand you don't like his evidence that you put on, the state put on, but he does say things that indicated, that seemed to indicate that he was fearful. Now, it may be totally self-serving. It may be totally inconsistent with other evidence. That's a different question. But when he's talking about having 3 dead bodies, that indicates that at least he's saying something that indicates that he was fearful of being one of the dead bodies. I mean, in the context, you have to understand it that way, don't you?
I didn't understand it that way. Assuming that he
who
was
were the dead bodies?
At that point, I'm not sure he knew who was murdered in that case and not. I mean, everyone was shot. Everywhere in the drug shed was shot. But assuming it was it would have been the decedent, Mr. Stallworth.
But he was talking about more dead bodies than there were.
Correct, Your Honor. And I'm assuming, in the light most favorable to Mr. Stallworth, it was him, his girlfriend. He never articulated how that would happen or why that would happen.
Again, this is not, the standard here is not a rule based on the articulateness of a defendant, is it?
I think a defendant...
Or the articulateness of any particular witness.
I think a defendant needs to point to a statement or an act that would lead a reasonable person to believe that they had to commit the crime or avoid whatever harm that outweighed that crime.
Isn't the real question here? All right, so the 3 bodies comment. I guess the real question is, what is that evidence of? Okay, because I think in order for the state to prevail, that has to be evidence of something other than duress. Because if it's evidence of duress, our cases say he should get the instruction. So it seems to me that what you're really arguing is that statement is evidence of Stallworth's subjective fear, not of Miles's duress applied to him. Am I right about that?
That's precisely what my argument is. The 3 dead bodies comment might be his subjective fear. Let's say it is. Would a reasonable person believe that based on the context of the evidence? No. And reasonableness is the cornerstone of the jury instruction.
When you say a reasonable person not believe the sincerity of the fear, but you're saying would a reasonable person, in light of the facts that are the evidence, would a reasonable person perceive duress?
No, a reasonable person would not feel that they had to commit the crime to avoid some imminent harm.
And so we're not really but I think the question is, one part of this is what was Stallworth? Was he afraid? It seems like there's clearly the 3 bodies thing that you can check that box, but isn't part of the inquiry like what is the evidence of what was in front of him objectively, and what an objective reaction to that would be?
Correct, Your Honor. I think the lens always has to be objective.
Right, and so what is that?
Can't be subjective.
Right, and so what is the evidence of that? I know you say there isn't, but like what is it that we're arguing about as to whether X, Y, and Z is objective evidence, or right?
I'm not sure I understand the question.
I think his question is your point that there's no objective evidence that would have put a reasonable person in fear, even if we stipulate that he was in fear.
That's correct, Your Honor. Even based on Mr. Stallworth's statements, and they changed, but we're not weighing them, so even Mr. Stallworth's best statements, in the light most favorable to Mr. Stallworth, would not put a reasonable person in fear, or would not meet all of the elements of Mickle for a duress defense. And I know that the statement the court made in Stallworth was that a defendant's self-serving assertion, which is not supported by any other evidence, will not support the reversal of a trial court's discretionary decision not to give the duress instruction. I know that sounds like the court is weighing in talking about the weakness of Mr. Stallworth's statements, maybe, but it's also talking about the strength of the court's discretion. And the court has a lot of discretion in these cases to decide whether objectively a reasonable person would act out of duress.
What about the court?
What is the standard for determining whether a defense instruction will be given?
If a defendant gives some evidence,
just the general standard applied to this and other defenses. What is the standard?
My argument's not is duress is different. It should be a rare defense, not like self-defense. But even in a self-defense case, a defendant has to give some.
Is the standard different for duress than for? Is the standard of what is that applies to determine whether the defense should be given? Is it different for duress than for other things?
There's a lot more elements to a duress defense.
Well, I understand that. I understand defenses are different, but isn't there a general standard about what a judge has to, the determination that the judge has to make in deciding whether a defense instruction should be given?
If there's any evidence that supports all the evidence.
Any evidence, right.
That supports all the elements. I mean, I don't think a defendant should get a duress defense just because he meets one or two elements of the jury instruction. That would just confuse the jury when duress hasn't been demonstrated, especially when the jury instruction says that the defendant has the burden of production. Now, the Fifth says once the defendant has met the burden of production, then the state has to overcome that. The First follows the common law, which says that the defendant still has to prove they still bear the burden of proving their affirmative defense. So it is a lot different than self-defense. And it should be a rare defense. It should be like entrapment. It's only in those rare cases because citizens have a duty, like I said, to abstain from crimes, resist duress, and do whatever they can to get out of these situations. And not one of the elements is not put themselves in these situations, which could lead to this type of crime, which Mr. Stallworth, by his own admissions, did. So in this case, it cannot be said that the lower court abused its discretion by denying the jury instruction on duress.
Let me ask you about some of the statements the First DCA made, notwithstanding what the trial court did. They said, this court may not reweigh the evidence, meaning in their determination of whether the lower court had abused its discretion. What do you think they meant?
May not reweigh the evidence.
Yeah, there was, the lower court deemed there was insufficient evidence to support a duress instruction. This court may not reweigh the evidence. What do you think that means?
I think it means that the court cannot second guess the lower court's use of its discretion. I don't know that there's any evidence that the court weighed evidence. It simply found it applied the Mickle factor. I mean, it cited Mickle.
The lower court
cited Mickle and applied Mickle, and so I'm not sure what the DCA meant there. But
when you say that there's no evidence that the district court weighed the evidence, that baffles me. When the district court has specifically denigrated the evidence as self-serving, that's weighing it. That seems to me, I don't know how you escape that.
I was speaking about the lower court. There's no evidence that the lower court.
I'm sorry, I missed the thread there.
The lower court religiously applied Mickle and cited Mickle and went through the factors and decided that Mr. Stallworth was not entitled to the jury instruction on duress. Stallworth, it has some language that lacks clarity, to be
Well, it seems
Frank,
pretty clear.
Well,
I think it's clearly erroneous.
I think, well,
Or at least clearly in conflict with a vast body of case law.
the result isn't. If we look at what the trial court did in applying Mickle and what the facts are, there's no instance where Mr. Stallworth would have been entitled to a duress instruction. And it wasn't his only defense. In his closing argument, he simply downplayed his involvement, which he did during his statements anyway. So it may be a harmless error if it's an error at all. But despite the language in Stallworth that's problematic, I don't think it conflicts with Hall, which is the stated conflict. That talks about a harm that's existent at the time, where this is whether being in the presence of a person that's you perceive subjectively to be dangerous is a reason to get the duress defense, and it shouldn't be. They should be able, I mean...
Well, but there is some objective evidence that this person was dangerous, isn't there?
I don't see any direct evidence that, well, that he committed the robbery,
yeah.
but I mean...
a most brutal sequence of events.
But Mr. Stallworth was already part of the crime when the violence there had started. I mean, he says that he got into the crime because, well, he saw that there was masks and there were guns, and his quote was, I told myself, I'm not misquoting him, but in my own words, he said, I told myself, do what you can. And he went along with the robbery. But he never pointed to, Mr. Miles obviously never pointed a gun at him. Mr. Miles, by Mr. Stallworth's own admission, they hung out all day. At one point, Mr. Miles was Mr. Stallworth's cousin. Another point, he wasn't. I guess we go with it. He wasn't in the light most favorable Mr. Stallworth. But if this is going to be a case, that I guess the closest analogy would be a mob boss that, some might make indirect threats. Do you have a chance to go to the police? Do you have a chance to avoid this? These are all things that the defendant has to establish. And if they don't get the jury instruction. In this case,
was there evidence that he participated in the planning?
Oh, there was. His girlfriend, if we were weighing evidence, not suggesting that we would, his girlfriend's testimony, completely... And had he gotten the duress defense, I think his girlfriend's testimony would overcome that defense, because she says he was with a mask, with a gun, goes to the robbery, comes back with, they all came back with more guns than they had initially. Also, 3 types of guns were fired on the scene. Her testimony, the 3 men took 3 guns to the scene. But getting out of, weighing the testimony, he didn't establish he didn't meet his burden of production for each element of the jury instruction. And so in the end, the trial court did not abuse its discretion in denying him the duress instruction. And so the result in Stallworth was the correct result, and I'd ask this court to affirm Stallworth and state that I would ask this court to decline jurisdiction, enter an order dismissing jurisdiction, because nothing in Stallworth conflicts with the language in Hall, and in the alternative, affirm Stallworth because the district court reached the right result. Thank you, Your Honors.
Thank you.
So Mr. Stallworth was entitled to the defense instruction based on the evidence at trial, and he's also entitled to all the reasonable inferences that are drawn from that evidence. And reasonable inferences based on the totality of the circumstances he was facing is that he feared this Miles and the other co-defendant, and that he feared if he did not go along with the robbery that they would kill him or kill his girlfriend.
What is the evidence that that Miles applied duress?
The only overt evidence is the look that he gave, as Justice Labarga mentioned, the look that
And how does the look come in to, that is Stallworth's statement, right? Or is there any other evidence of the look?
Stallworth statement. They are originally going to, Stallworth thinks they're going to the shed to buy drugs. It's a trap house. It's a place where drugs are sold. And as they are getting out and approaching the shed, the co-defendants produce masks and guns. And when Stallworth is hesitant, is taken aback and hesitant at this production of masks and guns, that's when Miles gives him the look that he interprets as that this is serious and that I'm going to be in trouble if I don't go along with this.
And he tells him to put the mask on.
And he orders him to put the mask on. And he says some language that I'm not going to repeat, but it's not polite language. And he orders him to put the mask on. That's correct. I'm sorry?
Is it a threat?
It's not an overt threat and a classical I'm going to kill you if you don't do it type of way, but it's certainly, I think that he could interpret it that way. He knows the man, he's in the circumstance, and he obviously interpreted it as a threat. And whether or not that interpretation is reasonable is for the jury to decide after it gets the duress instruction.
But to be clear about this, duress does not require a threat, correct?
That's absolutely correct.
Is the word threat even in the instruction?
The instruction...
Or I don't know. I'm not sure I'm looking at the right version of it. But it's basically about danger or emergency.
The Hall court uses the word danger, and then the old version of the jury instruction says danger or emergency that threatens significant harm. So threatened harm is what the old version say. The new version of the jury instruction again calls it a danger that would cause death or serious bodily harm, the perceived harm or of death or serious bodily injury.
That was imminent and impending.
Yes. And so whether his fear is objectively reasonable is a question for the jury. And there's no requirement of an overt threat, specific words, I'm going to kill you if you don't do this. He has to believe, and then his belief has to be reasonable, that he's facing this harm, this imminent, immediate, real harm.
But the court, in deciding whether to give the instruction, does not have to decide that it is reasonable.
I agree. No, he does not. He just has to.
But that's not just that you agree. Isn't that clear in our law?
Yes, it's just check, as you said, check the box. There's evidence that's been admitted. Check the box. Give it to the jury. Give the instruction to the jury. The jury decides the reasonableness.
No, but the judge doesn't have to decide whether the evidence that's put in is such that if it's believed, it would constitute as a matter of law evidence that's objectively meets the objectively reasonable threshold.
The case law, case after case after case, says it does not matter if the trial court finds the evidence to be weak or improbable.
Right, I know, that's not what I'm saying.
I'm saying
if I believe everything you say, if I believe that you gave me, that the guy gave Stallworth a look, right? Would that be evidence that could lead an objectively reasonable person in Stallworth's position to be under duress? That's the question, I think. Not did he give them the look or whatever, but if that's true, would that satisfy the objective test to put a reasonable person in fear under all the circumstances?
Well, and again, I think that's for the jury to decide whether his belief was reasonable.
Okay, but that's okay. I don't think that the objectively reasonable thing, that's a question of law. That's not, the jury's job is to find out who did what and whatever, but for us to say, we can say as a matter of law that such and such is within that zone or it's not. I
think that constitutes the trial court weighing the evidence.
Okay. I disagree with you, but no disrespect.
I understand. Absolutely no disrespect.
No, I know, of course.
As far as the first DCA mentioning re-weighing the evidence, I think it's almost a Freudian slip that the trial court did weigh the evidence. It's clear the trial court was looking for an overt act. It didn't get it, and it didn't want to use the self-serving statements that Mr. Stallworth gave, and admittedly self-serving. But what defense statements and in police interrogations, many of them are self-serving, and there's still evidence, and they still can be relied on to get a defense instruction. There's multiple cases that give the self-defense instruction based on just self-serving statements in police interrogations. With that, I would conclude and ask the court to order a new trial on the felony murder, and then based on issues on the other issues that I raised in the brief that we haven't discussed today, is not allow retrial on the aggravated battery and the the premeditated murder. Thank you.
It's all a package.
I'm sorry?
It's all a package. Thank you.